Hello, welcome to EPG Pathshala. I am Dr. Anureka Chariwag, Assistant Professor at Department of Sociology, Savitribai Phule, Pune University. I am coordinating the paper on Sociology of Gender. Today we are going to discuss the module Violence at Public Spaces and Workplace. In this module, we will introduce the students to the various debates of violence against women in general and specifically in India. We will also address the national and the global debates. In global, we will especially focus on the role of United Nations and the response of United Nations towards violence against women. In this module, the important keywords include violence, violence against women, rape, sexual harassment of women at workplace, acid attack, state and the role it plays through legislations. The module Violence at Public Spaces and Workplace is structured in such a way so as to give a basic understanding of violence itself. In doing so, it uses a dictionary meaning of the same and subsequently attempts to define it through social scientists. Later on, the issue of violence against women and its various forms are discussed in detail. An attempt is also made to locate violence against women in the global international organizations and conventions framework. The idea is to argue that violence against women now has a global presence in terms of initiatives taken to curb it. The module thereafter shifts to the Indian context and outlines three major manifestations of violence against women. These include rape, custodial rape and sexual assault, sexual harassment of women at workplace, and coercive crime against girls and women, that is, acid attacks on women and girls. The module in conclusion argues that patriarchy and male domination over the female can be seen as the underlying reason of violence against women in the broader context and India in particular. Understanding violence. At a very basic level, violence can be understood as any individual's behavior which results in physical harm of the other person or group. Such a behavior is characterized by aggression and impulse aimed towards other person. Merriam-Webster Dictionary defines violence as a use of physical force to harm someone, to damage property. Similarly, Oxford dictionaries define it as a behavior involving physical force intended to hurt, damage or kill someone or something. In her seminal essay on violence, Hannah Arendt had outlined basic contours of violence. For her power, strength, force, authority and violence are to be understood in relation with each other. She states that violence is distinguished by its instrumental character. Phenomenologically, it is close to strength. John Galtung has defined violence in terms of direct and structural violence. Direct violence involves personal injury, whereas structural violence elaborates that any structure of social injustice in any society. Thus, we see the act of violence does not only include the physical harm done to the other, but also the mental as well as psychological acts of torture and mental harassment are also included in the same. Violence against women. One of the most visible and widely spread forms of violence is violence against women, which is very specific to women per se. It is because of the person being a woman she suffers from such a violence. Some of such violence against women include domestic violence, sexual assault, rape and molestation among others. Regards the nature of violence against women, D. Kisardi has distinguished between narrow and broad definitions of violence against women. The former emphasizes mainly on physical abuse or sexual assaults involving force penetration as the most common, whereas latter highlights emotional, verbal and spiritual abuse. Similarly, Krishna Raj has argued that there are crimes specifically directed against women such as rape, sexual harassment, abuse, sexual exploitation, prostitution, domestic violence and pornography. The forms may vary between cultures and settings, but what is near universal is male violence far exceeds female violence. Violence against women sometimes is also known as gender-based violence. It refers to the violence that targets individuals or groups on the basis of the gender. Gender-based violence and violence against women are often used interchangeably, as the most gender-based violence is inflicted by men on women and girls. Various manifestations of the gender-based violence as outlined by Schuller are presented in the table. Violence and global international organizations and conventions. Any attempt to locate violence against women at the global level begins with a certain international agreements in the said context. Some of these are Convention on the Elimination of All Forms of Discrimination Against Women (CEDAW) in 1979 and the 1993 United Nations Declaration on the Elimination of Violence Against Women. With reference to violence against women, CEDAW addresses it specifically through General Recommendations 12 and 19. An attempt is being made here to highlight some of its major themes. It was on December 18, 1979 that the Convention on Elimination of All Forms of Discrimination Against Women (CEDAW) was adopted by the United Nations General Assembly. Subsequently, it entered into force as an international treaty on 3rd September 1981. It has altogether 30 articles divided into 6 parts. In the beginning itself, Article 1 states that for the purposes of the present convention, the term discrimination against women shall mean any distinction, exclusion or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of the marital status, on the basis of equality of men and women, of human rights and fundamental freedom in the political, economic, social, cultural or any other field. The 1993 United Nations Declaration on the Elimination of Violence Against Women effectively defined and outlined its various forms. According to the declaration, the term violence against women means any act of gender-based violence that results in or is likely to result in physical, sexual or psychological harm or suffering to women, including threats of such acts, coercion or arbitrary deprivation of liberty, whether occurring in public or in private life. According to the United Nations Development Fund for Women, UNIFEM, violence against women can include physical, sexual, psychological and economic abuse, and it cuts across boundaries of age, race, culture, wealth and geography. It has many manifestations, from the most universally prevalent forms of domestic and sexual violence to harmful practices, abuse during pregnancy, so-called honor killings and other types of femicide. According to World Health Organization, violence against women takes many forms, including intimate partner violence, including physical, sexual violence, including conflict-related sexual violence, forced and early marriages, trafficking, female genital mutilation, honor killing, etc. A UNESCO publication by Kosambi defined violence against women as sexual exploitation, forced prostitution, rape and sexual harassment, physical assault on women and girls, leading even to deaths within the family context. Thus, this definition not only includes the public sphere but also looks into the private familial space, wherein notions like domestic violence, battered women, marital rape, among others. According to Amnesty International, violence against women is rooted in the belief that women deserve less social power and it is therefore acceptable, maybe even necessary, to exert power over them. This mindset also drives many other forms of violence such as racism, homophobia, classism, ageism and religious persecution. The Beijing World Conference in 1995 identified violence against women as one of its 12 priority areas. In the decade of 2000, the Human Rights Committee and the Committee on the Elimination of Racial Discrimination also focused on violence against women and argued for its resolution as soon as possible. Violence against women in the Indian context. The Constitution of India addresses the violence against women through a plethora of its mechanisms like Articles 14, 15, 15.3, 16, 39A, 39B, 39C and 42 among others. At the global level, India has also ratified the Convention on CEDAW in 1993. Some of the crimes specific to women are termed as crimes against women, and these are identified under various sections of the Indian Penal Code (IPC) 1860. These include rape, Section 376 IPC, kidnapping and abduction for different purposes, Section 363, 373, homicide for dowry, dowry deaths or their attempts, Section 302, 304B IPC, torture both mental and physical, Section 498A IPC, molestation, Section 354 IPC, sexual harassment, Section 509 IPC, importation of girls up to 21 years of age from foreign country, Section 366B IPC. Additionally, crimes under the special and local laws include Immoral Traffic Prevention Act 1956, Dowry Prohibition Act 1961, Indecent Representation of Women Prohibition Act 1986, and the Commission of Sati Prevention Act of 1987. Table 2 represents various crimes against women during the 2009-13. According to the National Crime Bureau Report 2013, there were altogether 33,707 incidences of rape, Section 376 IPC, and 51,881 incidents of kidnapping and abduction, Section 363, 369, 371 to 373 IPC, 8,083 incidences of dowry deaths, 1,18,866 incidents of cruelty by husband or his relatives, 70,739 incidents related to assault on women with intent to outrage her modesty, many others. Thus, we see that in spite of the plethora of laws and legislations, violence against women is still on the rise and keeps on increasing. In the foregoing paragraph, 3 specific forms of violence against women at public spaces and workspace, that is rape and sexual assault, sexual harassment of workplace, acid attacks on women and girls will be discussed in detail. Rape, custodial rape and sexual assault. The brutal and numbing gang rape of a young female paramedical student on the night of 16 December 2012 in the moving bus in New Delhi and her subsequent death after being hospitalized for a few days despite her struggle brought in the fore once again the vulnerability of women in public space. Following the massive uproar and protest by the general public, a 3-member commission headed by the former Indian Supreme Court Chief Justice Jagdish Sharan Verma was formed to review the present law so as to provide speedier justice and enhance punishment in the cases of aggravated sexual assault. When the module was written, the conviction and quantum of punishment awarded to the perpetrators of such heinous crime was still sub judice. So the module does not make a comment on the same. Rather, it will highlight some issues pertinent to violence against women in Indian context. The act of rape results in severe mental and physical trauma, wherein the rape survivor tends to lose the sense and worthiness of life. Apart from this, she is seen by the society at large as a helpless victim who needs sympathy as well as protection in terms of women's shelter homes. As a result of the societal apathy which tend to shun the rape survivor due to the stigma attached with the rape, subsequent hurdle in a way of getting justice is a snail-paced judicial probe into the same. The latter has financial implications also. It is due to these reasons that conviction rate in such crimes is very less. Regardless of constitutional provisions, rape is a crime against human rights and violates persons' right to life contained in Article 21. The term rape is legally defined under Section 375 of Indian Penal Code 1860 and also details punishments for the same. Whenever a man penetrates or does sexual intercourse with a woman without her consent or will, it amounts to rape. The rape law under Indian Penal Code has gone through a lot of amendments. In 1983, amendment was made in Section 376(2), that is custodial rape, Section 376A, that is marital rape, and Section 376B to D, that is sexual intercourse not amounting to rape, were added. Additionally, the issue of rape of a woman who is under 12 years of age is outlined in Section 376(2)F. The issue of custodial rape is mentioned in Section 376, subsection 2A, B, C, D. The engagement of women's movement and organizations with the state and incidents of rape are entangled with rape cases of Ramiza B. in March 1978, Mathura rape case in 1972 and Maya Tyagi in 1980 and subsequent acquittal of all those involved in these cases. In September 1979, the Supreme Court of India acquitted the accused policeman of Mathura custodial rape case. It led to public uproar and subsequently eminent feminists wrote an open letter to the Supreme Court critiquing its judgment and thus highlighting the colonial and male-dominated notions of rape. The flawed justice brought home the need for a sustained campaign for reform of the laws relating to rape. It was after a long struggle against the biased penal code that the Indian Evidence Amendment Bill 2002 was introduced in the Lok Sabha on November 28, 2002. It intended to remove the Section 155(4) of the Indian Evidence Act 1872. The Indian Evidence Amendment Act 2003 provided deletion of the Clause 4 of Section 155 by specifically providing in Section 146. Again, the Indian Evidence Amendment Act of 2006 was introduced in the Rajya Sabha on 12th May 2006 to further amend the Indian Evidence Act of 1872. It stated that in the Evidence Act 1872, after a section 114A, the following sections shall be inserted, namely 114B, in a prosecution for culpable homicide or murder, as the case may be, of a person by a police officer, the court may presume that the death was caused when that person was in the custody of the police by the police officer having custody of that person during that period after taking into account all the relevant circumstances and facts unless otherwise provided by that police officer. It is pertinent to note that the act of rape is not simply an act of aggression or crime, rather it should be located within the framework of patriarchy and or male domination. Such a framework is further fragmented on the lines of religion and caste. It has been pointed out by many that rape and sexual assault of women belonging to the opposing camp is an effective tool of domination of the other side. The rape of the lower caste women by upper caste men does not only imposes male domination over her but also attests to the pervasiveness of caste ideology. Similarly, the incidence of sexual assault and rape of women belonging to the minority community during rites has a shrill overtone of religious majoritarianism. Thus, the act of rape need not only be seen as a manifestation of violent male domination but also needs to be problematized along religious and caste lines. Sexual harassment of women at workplace. According to Kishwar, sexual harassment occurs when a woman, despite having clearly indicated her disinterest, is pressured into tolerating or accepting undesirable sexual advances by someone who is in a position of power over her and is able to harm her interest if she declines these advances or to have sexual relations with him. Roy argues that sexual harassment of a workplace seriously impedes a person's professional growth and her ability to make significant contribution to society while eroding her self-esteem and self-confidence. Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013 aims at addressing any sexual harassment incident in relation to any workplace. Here, workplace includes any department, organization owned or financed directly or indirectly by the appropriate government or local authority. Most importantly, it also includes any private sector organization or a private venture. For the sake of the Act, sexual harassment includes any one or more of the unwelcome acts or behavior, whether directly or by implication, including physical contact, advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. The historicity of this act can be traced back to the infamous September 1992 gang rape of Bhavri Devi and the subsequent acquittal of the accused by the court of law. It led to the filing of a public interest litigation by the Women's Collective Vishakha in the Supreme Court against the state of Rajasthan and Union of India. Subsequently, Supreme Court gave the judgment popularly known as Vishakha Guidelines. In the wake of the guidelines, various universities have formulated their own version. The formation of Jawaharlal Nehru University's Gender Sensitization Committee against sexual harassment can be taken as an exemplary example of the same. Menon has outlined certain barriers to the effective functioning of such guidelines, like reluctance of employees to set up committees that fail to understand the nature of harassment, among others. Similarly, Justice Verma Committee formed on 23 December 2012 to recommend amendments to the criminal law regarding swift addressal of sexual assault against women, has highlighted that while much has been said and done in the past several years about sexual harassment at the workplace, it is evident that this evil is still rampant in Indian society. The committee further made suggestions that regarding the same, clearly focusing on the sexual harassment of women at the workplace. Some of these are briefly discussed here. The committee suggested that Section 10(1) of the Sexual Harassment Bill 2012 emphasizes on conciliation between complainant and respondent. The section should be deleted, paper 128. Additionally, the rationale of Section 14 relating to punishment of women for filing false complaints should be relooked too. Committee also recommended setting up a separate tribunal to be termed as Employment Tribunal to receive and adjudicate all complaints of this nature. The committee proposed that domestic workers, along with women in the armed forces and police, agricultural workers and women students and staff of all schools and educational institutions should also fall within the ambit of the proposed legislations. Coercive crime against girls and women. Another issue of concern for violence against women is the increasing incidence of acid attacks on the girls and the women. According to Acid Survivors Trust International, acid violence is the deliberate use of acid to attack another human being. The victims of acid violence are overwhelmingly women and children, and attackers often target the head or the face in order to maim, disfigure and blind. According to Acid Survivors Foundation India, ASFI, it is a vicious, premeditated crime involving throwing of corrosive acid on the face or exposed part with intent to scar and disfigure the victim. It seldom kills but devastates the sufferer's life mentally, morally, physically and financially. The acid melts the flesh, sometimes to the bone. Such acid attacks are often committed by the jilted one-sided lover or as a result of refusing marriage proposal by the girl or the woman. The 226th report of the Law Commission of India, titled Inclusion of Acid Attacks as Specific Offences in the Indian Penal Code and the Law for the Compensation of Victims of Crime, 2009, specifically pointed out violent ramifications on the girl and the woman who suffer from crimes of acid attack. Additionally, it pointed out that Section 326 IPC does not cover the act of administering acid. The report further pointed out that there should be a separate comprehensive legislation so as to address such crimes more effectively. Criminal Injuries Compensation Board should be set up to provide financial help to the victim, taking her specific needs into consideration. The identity of the victim should be concealed so that victim is not intimidated or harassed by the alleged convict. Indian Penal Code was amended on the 2nd April 2013 with the passing of the Criminal Law Amendment Act 2013. The amendment resulted in insertion of sections 326A and 326B for specifically dealing with acid violence. According to the section 326A of the Indian Penal Code, acid includes any substance which has acidic or corrosive character or burning nature that is capable of causing bodily harm, injury, leading to scars or disfigurement or temporary or permanent disability. Section 326A, Section 326B of the Indian Penal Code includes punishment which is given to an accused. Section 326A lays down the punishment for acid throwing. The minimum punishment is 10 years imprisonment and it can extend up to life imprisonment with fine. Section 326B lays down the punishment for attempted acid throwing. The minimum punishment is 5 years imprisonment. It can extend up to 7 years imprisonment with fine. Subsequently, in the light of a PIL which was filed in 2006 by Lakshmi, an acid attack victim from Delhi, the Supreme Court on 18 July 2013 passed an order to regulate the sale of acids across the country. However, in the intermittent periods saw frequent such attacks on the women. Senthalir, while commenting on acid attack victims in Karnataka, laments that there is no widespread awareness of the first aid to be administered to acid attack victims, which is detrimental in minimizing the damage done. Additionally, two aspects are crucial in curbing this crime: strict law enforcement and a vigilant civil society that demands accountability. In an important way, Justice Verma Committee, formed on 23rd December 2012 to recommend amendments to the criminal law regarding swift addressal of sexual assault against women, has also recommended that acid attacks to be specifically defined as an offense in IPC and that the victim to be compensated by the accused. However, what is more important is the empathy reflected by the civil society towards such survivors. One needs to understand the aggressive and egoistic male psychology to comprehend such acid attacks. The male is unable to accept his defeat, howsoever momentarily, to the female. At the same time, such attacks can also be seen as a result of free play of male sexual advances, wherein the girl or the woman has refused the same. In conclusion of this module, Violence at Workplace and at Public Spaces, we have discussed the interrelationship between culture and violence against women. We have also looked into the social structures of inequality that pushes or kinds of increases the violence against women. We also do a critique of the binary of the oppressor and the oppressed, but rather see it as a much more complex category of violence. Further, we also have argued that patriarchy, especially in terms of its violent and aggressive context and experience, is what could be one of the major reasons that is facilitating violence against women in both public spaces and in workspaces. Thank you.